Well, greetings and salutations, test takers. This is Series 7 Guru coming to you from my off-grid studio, getting our kicks on historic Route 66 with another free ride practice test. Emily and I had decided that maybe it might be helpful to break this into two chunks. Remember, your test is completely random on the 66, but 45 of those questions are on laws and regs, and that's what we're going to do in this session. And then we're going to come back and do a second session on the investment vehicles, the 55 questions there. The idea being that it might be helpful for you to chunk it out and do it this way rather than sitting through 2 or 3 hours of 100 questions. So off to the races we go with our first performance opportunity. Under the anti-fraud provisions of the Investment Advisor Act of 1940, an investment advisor must disclose to clients.
Okay. The advisor has never been subject to disciplinary action. The number of clients with whom the advisor does business, that any transaction made on the advisor's own account are consistent with the advice given. Um, the association between the investment what I'm leaning towards D, the association.
Always go with your gut. Always go. Right. By the way, in this section of laws and regulations, 25 questions are on disclosures and unethical business practices. So disclosures, sunlight's the best disinfectant, is a big part of this section of the 66. Agent feels that his secretary is underpaid and decides to split his commissions on an 80-20 basis. This practice is,
Um, well, I know that they're allowed to split commissions if they're under the same. Um, I'm leaning towards C.
you are correct again,
Okay.
right? So, as we said, always trust your gut. Your first response is your best response. Now, I had a social media guy today, and he said that I had told people not to change answers and not to go back. And then he said that he did that on his exam, and thank God he did because otherwise he wouldn't have passed. And I go, hey, good for you, but that's not best practice. When a security is being registered under coordination, all the following are required except.
Um, Filing the administrator a statement of the maximum. I feel like that one's correct.
Oh man, when are you testing? I hope next week. You're nailing it. That's exactly right, right? Maximum underwriting discounts, commissions concurrently with the filing of the registration with the statement, right? So A
Mhm.
is certainly true, C is certainly true, and D is true, certainly true. Which of the following is true?
The Uniform Securities is a national law that each state administrators are permitted to establish regulations regulate testing and fees for brokers. The USA only provides for um the USA, and then federal is criminal. The state administrator has authority to amend federal law. I'm like, I'm leaning, what is true? Okay. I was like that. Okay.
Important on these exams for sure.
Yeah. I don't know, like C is kind of, but I think it's or okay, it's B. I think my
Yeah,
bet.
there you go. Yeah, good. Trust your gut. Trust your gut.
The problem with this exam is the language. It's like you have
And
to like
listen, I
kind
just
of
get
like figure out what you're reading and then dissect it.
state administrators are permitted to establish regulations related to the registration testing fees for broker dealers. Yeah, that's the true thing, right? The
Yes.
Securities Act is national law. That's not true. It's a template. The Uniform Securities Act only provides, no, it provides for a lot of stuff, not only. The
Hmm.
state administrator has the authority to amend federal law. No, 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 no.
Yeah, I was like, those don't sound right.
To transact business as a state as an investment advisor representative, a person must.
Um, they have to be registered. Okay, to transact business in the state as be registered as a representative of an investment advisor and have passed the appropriate NASA exam for IARs.
Right on. That's why you're taking
Oh
the test.
no, you
I hit
clicked
the wrong button. That was
broker.
okay. That's on me.
Yeah, it was.
Somebody see and I hit D. That's on me. So you got to let's just remember that one was on me for hitting the wrong button. Securities of which the following issuers are exempt under the Uniform Securities Act.
I know that it's like it's all of them, right? Or is it one, two, and three?
Well, we
Or
should have, yeah, we
yeah, I'm
should.
gonna go all of them. Oh,
It,
I got it
yeah,
wrong.
yeah. Remember, it's actually on this one. Whoop, let's go back. My bad. It's one, two, and four. It's not bank holding companies. I wouldn't worry at all about this.
Oh,
I wouldn't worry
okay.
at all about this. You know,
I read it too
so
quick. I didn't read that it was a
that's all right.
holding
That's all
company.
right. So, people get hung up on the registrations a lot. And I always tell them, how do we register a security?
Hmm.
Why not? That's only three or four questions, and people go down these rabbit holes. How do we register broker dealers and agents of broker dealers? Two, three questions. How do we register investment advisors and investment advisor reps? That's where the meat is. That's like seven or eight questions. So I'm not worried about the rabbit holes about national banks and state banks and who cares? What we care about is if we are going to register the security, how do we do it? Through coordination or through qualification, right? So
Right.
read all about that. Under the Uniform Securities Act, which of the following circumstances? What looks like I got the screen too big here. Let me shrink it down a little bit. Whoop. Under Uniform Securities Act, in which of the following circumstances may administrator take action against an advisory firm?
Um, so there's a certain number of years that you can take um that you
You
can go against the advisory firm. And I don't think 9 years ago, the administrator found the president of the firm violated. The firm has liabilities that exceed its assets. A minority shareholder with no management role, an investment advisor organized as a person. Um, can I read the question one more time? Under the Uniform Security
Yeah, under the
Act,
Uniform Securities Act, in which of the following circumstances may the administrator take action against an advisory firm? 9 years ago, the administrator of another state found the president of the firm violated securities laws. You were on the right track.
is it 3 years? Like, am I off with that?
No, it's 10.
Okay, it is 10. Okay, I knew it was not nine.
That's
So,
right. So
okay.
nine means that that's true, right? Because it's 10
Yeah.
is less than that. So one is true. The firm has liabilities that exceeds its assets. That makes
Yeah.
it insolvent, certainly. And
Hmm.
then three says a minority shareholder with no management role. So two things here, not minority shareholder, no management role. It's
Yeah.
corporation, they own X number of shares of stock in this investment advisory firm, and
Hmm.
they're bankrupt. That has nothing to do with the firm, right?
Yeah, so it's one and two. Okay, I had a feeling it was like 10. Like, I don't know. I have all these dates in my head.
Well, that is the challenge. There's a certain amount of minutia on this thing, right? Under Rule 2064-7, who cares? It's unlawful for an investment advisor registered with the commission to provide investment advice unless the advisor has adopted and implemented written policies and procedures. We call those WSPs, reasonably designed to prevent violation of the Investment Advisor Act by the advisor and supervised persons. Under this rule, investment advisors are required to perform a review of the adequacy and accuracy or adequacy of their policies pursuant to this no later than frequently, no later. So how often do we have to make sure this stuff is up to date?
I'm like leaning towards like quarterly or annually.
You're correct. It's either quarterly or annually.
Yeah. Um, I want to go annually.
You
I
are
might
correct. You
Oh,
are.
okay. Perfect. Thank you.
All the following statements regarding the selling of private placements under the Uniform Securities Act are true except.
They cannot be offered to more than 35 noms, that no commissions or other may be paid. That's
So we're
um I'm
looking
like leaning towards wait, because something about B, they cannot be offered to more than 35 non-institutional. Um, yeah.
What they're trying to do, very important.
That was like a trick
Private,
question for me.
well, the reason it's a trick is because they're trying to cloud your mind with a
Yes.
private placement under Reg D 506B, which
Uh-huh.
the question is not about, versus a private placement under
Right.
the Uniform Securities Act, right? They're entirely different things. As we see here in the rationale, it's no more than 10 on the Uniform Securities Act side. A client approaches an agent about investing in a risky security and insists on doing so, even when told by the agent the security is not suitable. What should the agent do?
A.
Yeah, we don't play God with people's money, right? It's not our money, it's their money. And, we'll object and we might even make them sign a, letter of non-solicitation, whatever, to, have evidence later, but we're going to follow their instructions. Long-term financial solutions, an investment advisor registered in 5 states, so it's not federally covered, 5 states.
Mhm.
Files Form ADVW, they're withdrawing the registration of the investment advisor. It is being acquired by another federal covered advisor. Oh, that's interesting. Gold and Silver Advisors LLC. Which of the following statements is correct?
Um, okay, so investment advisor indicating the business is closing. Sundry a copy is preserved for at least 3 years after the acquisition. Um, I'm like leaning towards D.
You are, man, you're on fire.
Oh,
Oh, I thought you got that right. Let's read it again.
oh, it was the other one.
It's 3 years. It's three. Yeah. So, pretty close. Pretty close.
They're both 3 years.
Yeah. Yeah.
And
I
this is
misread that.
both, yeah.
I misread that. So the reason we missed it is we said must keep copies. It's not the new firm that has to do it. It's the old firm.
Okay,
So got us both on that one.
yeah.
Under the Securities Act of 33, commercial paper is exempt from the prospectus delivery requirement unless its maturity is more than how many months? Kind of a weird way to ask this.
Unless, okay, it's exempt. Is it what, 12?
Is it, well, what's the definition of commercial paper? Is it,
It's a short-term money market.
well, it's a money market instrument for sure. But remember, we're not going to register commercial paper money market instruments. And
Right.
definition of commercial paper is 9 months,
That's
206.
what I wanted to say 9 months, but it was like, oh, it says it's exempt from the prospectus.
Yeah, remember, because we're not going to make it a registration.
Okay. I made the question more complicated.
Well,
Sorry. I
that's
was
okay.
like, I know the maturity is 9 months, but I was like, maybe he wants to know over. I don't know.
Which of the following would be included in the Uniform Securities Act definition of sale?
Um, it's definitely two. Accessible stock
Right
is
on.
a sale.
Definitely two.
And
You're
I'm gonna go 2 and 3. Hey,
2 and 3. Good job.
or at least I think.
Yep, you got it right.
Okay.
2 and 3. Gift of accessible. You should have known four, because four, remember, if I'm your creditor, I can sell that and not worry about the jurisdiction of the Uniform Securities Act, right?
Right.
So good job. The institutional trading desk of a major broker dealer received a substantial purchase order for 20,000 shares of XYZ common stock from one of its clients. While completing the paperwork to begin the order sequence, the firm decided to purchase shares of XYZ for its proprietary account. Under NASA, Statement of Policy of Dishonest and Unethical Business Practices of Broker Dealers and Agents.
So the institutional received a substantial purchase. While computing the paperwork, the firm decided to purchase in its Oh, okay. So this would be prohibited. It's front running.
That's exactly right. Right,
B.
right, good job. Under the Uniform Securities Act, when may an advisor legally have custody of money and securities belonging to a client?
When okay, if the investment um I I know I think it's definitely 3 and 4. It does not also have to, yeah, I'm gonna go 2, 3, and 4 just because that's the only option choice with,
Okay, let's look at,
I might get this wrong. I don't know.
well, let's see. These multiples are kind of depressing sometimes because you got two of the three correct, two and four. Three, the investment advisor does not also have discretionary accounts. It's not two, three, and four,
Oh, it's 2 and 4.
two and four, right?
Okay.
Oh, yeah, boom. Yeah, not a bad miss, though. I don't mind it if you get two-thirds of the right answer, right? An investment advisor runs an advertisement in the business section of the local newspaper. The ad describes the nature of the firm's model portfolio and indicates that it has outperformed the overall market by 800% over the last 10 years. And the firm therefore guarantees the client will keep pace with inflation. At the bottom of the ad in smaller print, the following statements: results are not guaranteed, past performance is not indicative of future results. These are not normal and cannot be expected to be repeated. This is an example of.
Um, I think it's an improper hedge. I mean, it's a violate. I know it's a
That's
violation.
exactly right. You can't put anything in your documents.
Yeah, that's guarantees.
I say, hey, this, Emily, is where you're saying that if I rip you off, you're not going to hold me accountable. So please initial this. This says that you're not going to exercise your right of rescission. This says that I can assign your contract without your consent. So you can't have any legalese that gives people limited, protections under the Uniform Securities Act. So very much a test question. You got it right. While a student at college 9 years ago, Joe was convicted of possession of marijuana, a misdemeanor in the state, and received a suspended sentence. Joe now resides in a different state where the same offense is a felony. Oh my God, this must have been written in the 50s. If Joe disclosed the matter on his application, Joe's registration may.
So it's definitely A or B because it was 9 years ago.
That's right.
Because the crime, yeah, it's A because it's a crime, the conviction in where he's seeking registration.
Well, it's actually
Or, or because it was less than 10 years ago.
no. You were on the right. You're on the right track. But remember, the question on your U4.
Oh, it's not a misdemeanor, isn't a felony.
That's right. So it doesn't matter that it's a felony in this state. The answer on the U4 is
Okay, so it's yeah, it's D. Or
right.
not, yeah. Okay.
Right. So kind
I
of a
have
trick
to
question.
read that better, but yeah, I have
Yeah,
you
kind of a trick question, right? So, in your U4, it doesn't say, have you been convicted of a misdemeanor that's a
yeah,
felony in some other state? It's just a yes, no answer. By
yeah.
the way, sometimes, people should just answer yes or no, right? Be done.
Mhm.
Under Uniform Securities Act, which of the following statements regarding the posting of surety bonds is not true? Not true.
So C is definitely the definition, so it's not that.
That's right.
Um, is it cash? It can accept securities instead of cash if posting of a bond is required. I'm like, okay, bonds may be required for agents of broker dealers. The administrator requires all broker dealers to post bonds, even if they maintain net capital in excess. I'm like torn between a couple here.
Yeah,
I think it's A or D.
you're correct. It is A or D. And remember, it's asking you what is not true.
I don't know if the administrator can accept securities instead of cash if posting the bond is required. They might be able to, so I'm leaning towards D.
You are correct. It's D. Remember, this is an important concept. I wouldn't get too hung up on it, but broker dealers, the state can impose on broker dealers a higher standard than they already have. And so here it's saying the administrator can make me post a bond even
Mhm.
if I maintain net capital. And when it comes to net capital record retention, that's not true.
Right.
Your manager is reviewing your customer accounts to detect trading irregularities. These are among the factors the manager would look at to determine if churning is occurring.
What do they mean by like the financial resources? I know it's the
In
number.
other words, can I churn you if, the financial resources, how much does the client have, right? So, there's two ways you could be looking at it. So kind of tricky. These are always the subjective judgmental questions.
Well, I
But
know it's 3 for
yeah,
sure.
the financial resources of the account. So, we have a kind of a general thing of most firms have a number. Let's say that your number, your firm is 2%. And I call you and I say, we think that you can reasonably make $2,000 on a $100,000 account. You're making $2,000 on a $50,000 account. So the financial resources would certainly be a consideration.
Okay,
Right.
yeah. So
We're
then
kind of
it's
thinking is a smaller asset based might be learned to turnover that could be churning. So that would be something we look at too. The number of winning trades versus losing trades. No, I use reduction of the ridiculous. What I mean by that is you tell your manager, well, hey, we shouldn't be looking at whether I'm churning or not. We should be looking at how many winning trades I made for the guy versus losing trades. And,
oh, so objectives of the,
yeah,
because
there
it's
you
not
go.
the marital status, it's
No,
one of
the wife or husband is not involved in this discussion. So 1 and 3.
that's a very weirdly worded question just
Well,
because when they
welcome
talk
to
about
Kaplan. Chuck Lowenstein's the subject matter expert at Kaplan, and Kaplan tries to be as big a jerks as the real jerks on the test. So, you know,
right.
stretch your
But
mind a little
turning
bit.
is usually like they're looking for you to say, oh, excessive trading.
Well, no,
Like,
absolutely, absolutely. And on the real test, it'll probably be more straightforward. It
yeah,
say trades are excessive and size and frequency can best be described as, and
right.
turning,
Then
boom.
I'd understand.
Associate Wealth Management is registered with the SEC as a registered investment advisor. As a consequence, if they have been any material changes, AWM must send a copy of its brochure and a summary.
I think it's with, is it, I think it's 90 or 60 days.
People get hung up on this all the time. 90 days is to the SEC,
But,
120 is to the customer.
oh,
Yeah,
okay.
90 days to the
I'm
SEC.
gonna write this down because I'm one of the people that has fallen victim to the
Yeah, so
confusion.
if this same question said, must send a copy of its brochure to the SEC, then the answer would be 90 days.
Okay.
But here it's to clients.
To the
Clients is
customer.
120.
Got it.
Boom. I have 120. By the way, Emily's kind enough to give people a free ride. And this was her idea, and I think it's a good one. We're going to do this in two parts. But one thing that I am doing, and remember, this isn't about you. Every once in a while, we get somebody who'll comment like, "Oh, can't you show us the answers?" And I go, "Well, it ain't about you. It's about the person taking the test, which would be Emily in this case." But we are showing the answers as we go, and I would be interested in your thoughts if you're watching this, if you find this a little more helpful than not showing the answers as we go. All right, Investment Advisor Act of 1940 addresses the issue of investment advisors. P.S. One more comment if you're watching this. We never post on the YouTube channel without permission of the person. Secondly, they wouldn't be on the channel if they didn't pass their exam. So you don't have to send me a bunch of comments saying, did they pass? You wouldn't be watching if they didn't. Right? So, Investment Advisor Act of 1940 addresses the issue of investment advisors maintaining custody of clients' funds and securities. In which of the following cases would the Act consider an IA to have custody?
Okay, so addresses the issue of investment advisors maintaining custody of client. Okay, it's definitely one.
Definitely one. You are correct.
Any arrangement under which you guys authorized or permitted. Okay, that's also two. That's correct.
Correct. 1 and 2.
Any capacity that gives the IA or supervised person legal ownership. Okay, I think it's one, two, and three.
You are correct.
And then receipt of a receipt made out to a third party. Uh, receipt of a check made out to a third party. I think it's one, two, and three. I don't know if it's the
Excellent.
receipt.
Excellent. Excellent. I love it. So let's talk about what a receipt made out to a third party. My firm was called Gamma Global Investment Advisors, and we used Schwab for execution and custody. So as much as we explain this relationship to people, I say, Emily, I can't steal what I don't touch. I don't have your monies in security. Schwab does. And you call me and say, "Hey, Dean, I got another $500,000 that I'm going to put in my account to manage." I go, "Great, I'll be looking for it." And I'm checking your Schwab account. I'm checking your Schwab account, and I don't see the 500,000. I open the mail today, and here's a check made out to a third party, in this case, Schwab, the broker dealer. Right? I don't have custody. What I have is a check that's made out to Schwab for $500,000. Do you remember the rule about this check from this third party?
I
So,
actually do not
so
remember
I
that.
have to forward this check to Schwab within 72 hours.
Oh, okay. I think I saw something
Yeah,
about
right. So, the phraseology on the actual test sometimes is inadvertently, right? In other words, this is an accident. It's not in the normal course of business. Now, that would be different than, by the way, if the check was made out to Gamma Global Investment Advisors, not a third party. Uh-oh. Right now, that's a different deal, right? Because that's a check made out to my investment advisory firm. The industry is concerned about the protection of both the firm and customer data. Where would it be acceptable to store this information?
that. I feel like I feel like you can have it on
Yeah.
all of
Yeah.
them.
You can just, you can have it anywhere place you how you want all of these. You just got
Yeah,
to make sure you got custody and control, right?
right.
A contract between an investment advisor and a customer may be assigned to another investment advisor provided.
Okay, a contract between an investment advisor and a customer may be assigned to another investment advisor. The client consents. The assignment is done 1 year after the initial contract. I feel like this is if the client consents to the assignment because you'd want the client to be aware
That is very much a test question.
someone else is taking over their
Yeah,
account.
that's exactly right. I mean, that's one of the dangers of buying somebody else's investment advisory firm because those clients have to give permission to, do that. It makes sense. It makes sense, right? Because your point, right? That I didn't hire you. Who are you again? Right?
Right.
In which of the following cases is a third party trading authorization acceptable?
Um, okay, so there's something about, okay, the spousal client sends an email saying that the client is given authorization. I don't think it's that one.
No, it's not.
Investment advisor makes a hospital visit to a client who is critically injured. While there, the client gives oral instructions to permit her daughter. I don't think, I don't think it's, I know there's something about how an investment advisor is able to accept oral discretion
Yeah.
over the phone and then they
Yeah.
have to, it's like it's 10 days or
You're
something
correct.
after.
That's a different question than you're being asked, but you're absolutely correct there.
Right.
On the
Um,
broker dealer side, we have to have the appropriate written documentation in place
right.
for the
But
for,
on the investment advisor side, it's like a little more lenient.
yeah.
Trades will be made through a broker dealer under common control. A client secretary presents a card signed by a client saying the secretary. Okay, presents a card signed by the client. So it the client secretary presents a card signed by the client stating that the secretary can trade in the account. Well, I, I'm like leaning towards
Yeah,
that
yeah,
because
this is a funky question.
it's written.
That's the only one that works. Yeah, I'm with you. It's a funky question, but all
I
the
had to
others
read it like
certainly.
3 times.
No, no, that's a funky worded question. Absolutely. But we could have used process of elimination. It sounds like that's what you did. You said, well, the spouse can't say that she can trade the spouse's account. It's got to come from the spouse, right? So the spouse says, I can trade the account. I go, well, I don't want to hurt your feelings, but no, I need the client to tell me you can trade the account, right? B, hospital visit, critically injured, they gives oral instructions. No. Trades may be made through under comment. No. Comment control is a separate thing. So yeah, given that answer, yeah, we got to take D. ABC changes its name to XYZ. It also changes its location. The Investment Advisor Act of 1940.
Amend Form ADV promptly.
Yeah, right. Because, we need to know where you're at.
Right.
So
That's what I would do.
yeah, that's the right thing.
Okay,
An
perfect.
agent and a broker-dealer maintain wrap fee accounts for several of the customers. Which of the following registrations is required?
Okay, they were, which of the following, the agent must be registered. The firm must register as an investment advisor
You are
because,
correct.
yeah, okay.
You are correct. Under the Securities Act of 34, which of the following would not be grounds for disqualification of a broker-dealer's registration? Not be grounds.
Being sued by a client,
Yeah. I mean, unfortunately, but we live in America. You can sue anybody about anything.
right?
Which of the following would probably be acceptable hedge clause under SEC interpretations?
Okay, which a hedge clause that seeks to
So
limit.
yeah, in general, we say these are bad. So they're saying on which of these situations would it be okay? Because it's usually not.
B doesn't sound bad.
A hedge clause that seeks to limit liability to acts done in bad faith. No,
Wait,
right?
hold on. A clause that limits the investment
I
advisors.
mean, that one's unacceptable because you're telling me that you're going to waive your rights to come after me for bad
Oh
faith.
yeah, never mind. I take it back. I'm like trying to like squint reading these.
Yeah.
Okay.
Yeah. So read each
Clause
one. So remember the hedge clause says I can't have legalese disclaimers that allow that say you won't enforce the Uniform Securities Act. Like, you agree that you're gonna allow me to sign your contract without your consent, or you're not gonna make me offer the right of rescission. So A is unacceptable because it tells you you're saying, Dean, if you are willfully misconducting yourself and managing my money, I'm going to provide you with a hedge clause that says you're not going to hold me accountable. A is unacceptable.
I'm going C.
There you go. Now, I like this one too because remember, this is very much like the NASA exam. You got to be real careful about the accepts or what you're being asked because it's real easy to squeeze triggers if you're not clear what's being asked, right? Investment advisors eligible to register with the SEC if.
Okay, an investment advisor is eligible to register if it would be okay. Um, I think it's okay. I know it's the has more than 100. I know that it's the rule with 110 million.
Yeah, but is
And
it?
then I know there's something about more than like, is it six in the most recent 12-month period?
Oh, well, hold on. Let's just start with this. The six has nothing to do with registering with the SEC.
Okay.
Minimis has nothing to do with being a federally covered advisor. The de
Okay.
minimis is only for state covered advisors.
Okay.
This question is about an IA registered with the SEC. A is not true because it's 15 states, not 10. B is not true because I just told you de minimis does not apply to
Right.
federally covered investment advisors. So it's
Uh-huh.
either C or D. There is no eligibility based on how many reps you have at the firm. That is never a part of whether you have to register or not with the SEC. If you have 100 million or more, you can choose between 100 and 110 to be federally covered. And here I'm saying to the SEC, I think that when I open my firm, I'm going to have $100 million AUM in the next 120 days.
Right. Okay.
I always think of here a guy named Jeffrey Vinnick. Jeffrey Vinnick was a legendary portfolio manager for Fidelity. He was an investment advisor rep for Fidelity Management Research, a federally covered investment advisor. And he got really tired of complying with the Investment Company Act of 1940, as well as Fidelity's internal kind of policies and procedures. And one day he quit. He said, I'm going out on my own. If you like me with all of the constraints of the Fidelity funds, you're going to love me now. I'm moving to Palm Beach. My minimum investment is $50 million dollars with a 5-year lockup. We know the guy's going to have $500 million dollars the day he opens his doors, right? So he's going to be a federally covered registered advisor because we have every expectation he's going to cross that number pretty quickly.
Right.
Under the Uniform Securities Act, what the following is true about the authority of the administrator?
can a cease and desist be issued like prior or I don't know if it's after, but I know it's prior.
Yeah, you can do that if there's a sense of urgency. Like I'm telling you to cease and desist now because by the time I shut you down, you could defraud all kinds of people.
Right. And then is valid for a maximum of 30 days. I don't, how long is a cease and desist act? That's the one part where I'm like, I think it's C or D.
You are correct. It is C or D.
I'm gonna go with my gut and I'm gonna go with C.
You are correct. Your gut's been right every time.
What's the rule with the how long it's because I don't remember that date.
There's no maximum on the cease and desist
That's what I
because
thought. Okay,
yeah,
because
it's
that's
part of
really
due process.
tripping me up.
Yeah, we're just going to have due process on that, right?
Yeah,
Summary. That's called summary.
perfect.
A unique requirement of those advisors who have custody is the filing of.
Custody. Is it, I
So
think
I'm
it's,
holding monies and securities.
it's E or H, I think.
You are correct.
I'm always down to two.
Well, the good news though, you're better at your 50/50s. I had a guy, I
It's
called him Mr.
crazy.
50/50. And statistically, you would think that if he's 50/50, he'd get 50 of the 50/50s right, but he got them all
Oh
wrong.
my goodness. I think I think it would be I'm gonna go my gut was E.
And your gut's once again correct.
Okay, perfect.
The
Because I
administrator of state A feels that Eli, who's registered in state A, is mishandling client's account. Can the administrator arrest Eli?
no.
Yeah, that's about as good as a layup as you're going to get on the test, right?
Yeah, I hope the whole
I
test
mean,
looks like
that's we got to get those right, right? They don't have a badge. The way I say it is they don't have a badge and a gun, right?
that. Right.
Written policies and procedures reasonably designed to safeguard customer information from cybersecurity threats would include all the following except.
Implementing a firewall or wait, hold on. Encrypting personally, you have to do that. Conducting periodic risk, yeah, maintaining a minimum. I'm gonna go B.
B as in boy.
Yeah, I probably got it wrong, but I'm gonna go B.
Yeah, yeah, you first missed in a while, but you did get it wrong because what we have to have is it,
Oh,
yeah, there's no minimum insurance requirement. You just either have it or you don't.
oh,
Some
okay.
people, but a firewall means that you have a firewall between the proprietary information of the customer and people who can get through that. So if I'm a cybersecurity guy, oh, they broke through our firewall. Now in house, a firewall is a wall the fire can't get around, right? But in
Right.
our business, the firewall means again a barrier to the entry of to access to that information.
Right.
Let's see what the Kaplan tells us here. Well, I guess but you got to have A, B, and C.
Well, I deserve that
It's
miss.
all right. That's pretty good. Look at that. That'll get. And when I think one of those is me hitting the wrong button. So under Uniform Securities Act, securities issued by which of the following entities are included in the definition of issuers.
Okay, wait. Issued. Okay. Securities issued by which of the liner? Is it D?
Ew. City of Birmingham, UK.
Wait, hold on. Sorry. Can I just reread it because I think I'm like not reading this correctly.
Well,
So,
you're right about one and two. You should definitely know the state of Michigan is an exempt issuer, governments and munis. Now, I'm not being facetious. This is
uh-huh.
called the North American Securities Administrator Association. And Canada is a part of North America.
Oh, okay.
And
So,
Alberta is a province in Canada. On this test,
so it's B.
Calgary is no different than the city of Detroit, Michigan. It is actually one and two. The
Okay. I'll miss
reciprocity,
this one.
yeah, okay, yeah, you're gonna miss it because remember, Birmingham is not a part
I
of North America.
yeah, I read it too. I didn't even see the UK. I was like,
Well, yeah, you're going a little
I
too
was
quick.
thinking, yeah,
But you were thinking Birmingham, Alabama.
maybe.
Right. The other thing I would just say, it's very low probability, very, very low probability. But if this said a sovereign debt of the UK, It would be. So the only one where provinces, political subdivisions are exempt is Canada. Every other thing, it can't be like Tijuana, Baja, California. It's got to be the Mexican government.
Okay, got it.
Plenitude Premier Solutions. Oh, did we miss two in a row?
Oh, darn.
Yeah,
Yeah.
well, let's make sure we get back on track here. Plenitude Premier Solutions is registered in State C. If PPS wishes to maintain custody of clients' funds and securities,
Um, um, if they want to, I think it'd be just, they'd have to be, notice would be given to the state C administrator on Form ADV.
right on, good job. Absolutely. Boom.
Thank God.
On the
Redeeming.
uniforms, yeah, we got to get back on track. On the Uniform Securities Act, it is not fraudulent if an agent.
Actively solicited orders in unregistered exempt securities, because all the other ones are completely.
Right on. You got it. That's exactly right. One way in which an investment advisor acting in the capacity, I'm just showing it to people again because people give me nasty grams and comments. Oh, you went so quick, I didn't get to say it. Well, there you go. One way in which an investment advisor acting in the capacity of an agent in transaction with a client differs from a broker-dealer performing the same task is that the investment advisor,
Isn't it the investment advisor can charge commissions and the broker dealer can't? Or,
well, you got it backwards. A broker-dealer can charge commission. One way was investment advisor acting in the capacity of an agent in a transaction with a client differs from the broker-dealer performing the same task. Broker-dealers charge commissions. The investment advisor, remember, needs permission to act as your agent in a trade prior to the.
oh, okay, yeah. So it's obtain the
Yeah, I think on the real
that,
test, this would be about an agency cross transaction. So there
right,
wasn't a lot of information to give us the context of the question.
right.
Prosperity Financial Investments, a broker-dealer with its principal office in State A, just applied for registration in State C. Which of the following individuals registered as agents in State A would be automatically
Oh
registered
my God. This
in
is
State C?
like
Ah.
principal. Okay. They have their principal office in state A and they just applied for registration in state C. Yeah. I don't think, I think it's the IAR, an individual registered as an IAR with PFI.
So
Or
when,
no, 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 no. It might be the officer.
there you go. Good
Yeah,
catch.
it's the officer.
Good catch. That's right.
Thank
That people are going to have to get registered. Which of the following actions by an investment advisor representative would be unethical?
Splitting commissions, who is registered? No, that's fine. Failing to enter a sale order. When the, okay, when the rep has discretionary authority, um, that would be unethical. Okay, recommending securities that result in negative returns. I mean, do they know that they're gonna be negative returns or like for C, like recommending securities that result in negative returns? Like it might
I don't
immediately.
know. I would read D. I mean, who knows? I'm not
Okay,
going to.
indicating in an advisory contract that in order to maximize with certain provisions, oh, it's D,
Yeah. So,
or at least I think, but
you are correct. And in our journey together, good news, you're coming to the conclusion of your journey with your 66 SIE 7. I know you well enough. Don't be getting caught churning your own brain on C. When you find yourself asking that kind of question, move on so you can say, well, maybe I don't need to, burn up brain cells on C, right? So you start to grind a little bit on C. I'm like, oh no, let's move on. Hey, woohoo! All right. So that is correct. Remember, that's very testable, by the way. We can't have any hedge clauses, right? So that's very much a test question. So now, by the way, recommending securities that result in negative returns in the customer's account, we don't know that. That's to be determined. But I mean, obviously we don't recommend uneconomical trades, trades that'll never work Which of the following would be considered when determining whether excessive trading has occurred in a client's account?
Um, what would be considered, I would say the performance of the account or the nature of the client's financial. I don't think it's the number of years, and I don't think it's the size of the
You're
company.
right. You got a 50-50. It's either C or D.
Performance of the account. All right, I'm gonna go C because it's not compared to other accounts.
Excellent, excellent. If you would
Sorry,
have
I have
said
to reread
D,
that.
if you would have said D, I would have gonna give you your first bad miss of our this
I
session.
just had to reread the bottom because I thought they
That's
just
right.
meant performance of the
No,
account,
yeah,
and that
remember because
would be like
we had a
size of.
very similar question earlier about this idea of I got winning trades versus losing trades. No.
Right.
An issuer is planning to offer securities for sale in state A and several other states. So it sounds like it's not an intrastate offering of securities. Which of the law statements regarding registration in state A under the Uniform Securities Act is not true?
Okay. The administrator may, as a condition of registration, the qualification rules, securities companies. Administrator may not, as a condition of registration, require the security to be deposited in escrow. The administrator may, by order, permit omission of items. Wait, permit omission of items of information. I'm gonna go C.
Okay, well, the administrator may, it depends what emissions we're making, right? If it's not a
Oh,
material emission, right? So the
okay.
answer is not true. So C is true. By
Okay.
the way, the only reason C is true is because it's omissions that are not material.
Okay, that's what tripped me up
Okay,
because
yeah. But you're
that's
right.
where
If that
my
would have
mind.
said permit omissions of material items, then you would be correct. So non-material. Let's see. The answer is the administrator. This so B is false. The administrator may not, as a condition of registration by qualification, require security deposit in escrow, and the proceeds are being counted until you receive a specified amount. No, I think it's kind of a funky one. Securities issued by which of the following are exempt from registration disclosure under the Uniform Securities Act?
Okay. Securities by which of the following are exempt from registration? Okay. I need to redeem myself here.
Yeah,
I'm gonna go United States or any territory, state or political, banks and saving, common carrier. Is it C or D?
it is CRD.
I'm gonna go banks and savings institutions. I want to say it's all four.
Good job. Excellent. Yeah, one more another time. We trust your gut. It's correct.
Thank
An
you.
income-oriented customer has a discretionary account with an agent. If the agent purchases a speculative growth stock on behalf of the customer, under the Uniform Securities Act, this is considered,
Okay, so they want income oriented and they pick growth. That would be an unsuitable transaction.
yeah, because we got to determine suitability, right?
Right.
Which of the following actions by an investment advisor registered in 3 states is permitted?
Okay, which of the following actions? Okay. Guaranteeing a rate, no, as long as the firm's brochure indicates that the fees are announced in the first place. You could technically stating in
Is
the
permitted.
advisory that the fees will be no, delivering a brochure within 48 hours. Isn't that, I think it something to do with the brochure, you do it and then there's like a certain amount of time. I'm like leaning towards D or
Well,
uh,
that 48 hours is about if I didn't give you the brochure, I got to give you 15 days to kind of decide whether you want to, get or 5 days to do it. So that's a different answer to a different question.
I'm thinking B sounded
There you go.
fine.
There you go. That's exactly
Like
right.
I was really leaning
And
towards
then you just got to make good on that. Whatever it is you said, you got to make good on that, right? So,
right.
mhm. Right. So the five
Perfect.
Jacob version is about state advisors when we haven't given you the brochure. So there we go.
All right. Sweet.
Included in the fiduciary relationship between investment advisor and client is the responsibility.
Okay. Included in the fiduciary, provide tax advice, disclose the tax consequences of a Recommend only non, okay, recommend only non-affiliated broker-dealers for execution. Recommend only non, is it the attorney? Recommend only non-affiliated attorneys to clients seeking legal advice. I think it'd be D, I think. I,
We're
or
supposed to have a
disclose the
we're
tax
supposed to have a
consequence.
general understanding.
Or I'm between B and D. Like I
You're
really
correct. It's either B or D.
am. Okay, hold on. Provide tax advice as an integral part of the client relationship. No. Disclose the tax consequence. Yes, it's B. I had to
There
read
you
it
go.
again.
There
Like
you
you
go. Love it.
always have to disclose.
Love it. Love it. Love it.
Okay.
That'll get it done. So now, what we're doing, this was Emily's idea, and I think it's a wonderful idea. We'll be calling this part one, laws and regs, or part two, depending how it works out. Thanks to our friends at Kaplan for allowing us to give you a free look on this Kaplan content. You can buy Kaplan products and services, and I highly recommend to QBank with a 15% discount code, Guru15. I'll put in the video description a link with that, as well as what the price is for the QBank. I think it's like 50, 60 dollars for the whole thing. And then we're going to circle back and we're going to do now the 55 questions that are the other part of the 66. So what we're kind of doing is on randomizing it and hopefully, breaking it into more bite-sized chunks perhaps for you. Remember, inch by inch, your 66 is a cinch. Yard by yard, your 66 is hard. And we'll see you for part two.